And good morning. Thank you for staying with us on Citizen Extra. I am Ann Kiguta. We're just counting minutes to the beginning of hearings in the petition challenging President Uhuru Kenyatta's re-election at the ballot on October 26th. We've got our crews standing by to bring you more information on that in studio. We also have a panel of analysts who will be helping us look into these issues. But first, we want to take you straight to the Supreme Court, where our Francis Gashuri and Sam Gituku are standing by for us this morning. And good morning to both of you. Sam, I want you to kick us off with just some housekeeping. First, all parties present at court as we speak, and have you seen the judges as well?
Well, good morning, Anne. We have seen several lawyers represent the different parties in these two cases making their way into the courtroom, including those persons who've been joined as interested parties, as well as those who have been joined in this case as friends of the courts. We have seen the Attorney General, who is an interested party in the petition number 4, that is the one involving John Jomue and Khalif Khalifa, who want the election of the president nullified. But just basically what we're expecting this morning, as soon as the judges make their way into the courtroom, is to make that determination. They're supposed to give a ruling on the matters, the application by John Jomue through lawyers Harun Dube and Juliet Soweto, where they're saying that they want a scrutiny of the servers that were used in this election. They want a scrutiny of the KIMS devices, the logs that were used to transmit results from the polling stations to the different tallying centers, that is at the constituencies, as well as the National Tallying Center. They also want the SD cards that were used in this election also brought in court and scrutinized, and sort of an audit of all the logs that were involved in the infrastructure of handling this election. But you will recall that yesterday, during the submissions before the court, the lawyers representing IEBC as well as Uhuru Kenyatta were saying that it would not be necessary to go that direction, bearing in mind that all that information that they are looking for is contained in a hard drive. But that hard drive, which they say is about 48 GB, the lawyers representing the petitioner were saying that they have not been able to peruse it because it was submitted to them quite late, just the day before yesterday. And so the ruling by the judges will be looking at the possibilities of going through the scrutiny process like happened with the other petition in August, or should they advise the petitioners to go and look at the data that is contained in the hard drive, so that they see if all the information they're looking for is contained in that hard drive, and whether there should be anything that should call for further scrutiny. Also, and the other thing that they will be looking at is the idea, the request to have the Form 34s, that is 34A, 34B, and 34C, the originals, brought to court and also allow for scrutiny, because they are saying they want that. But IBC was yesterday saying that already there are certified true copies of the originals that have already been submitted through the Supreme Court registry. So they are saying that should be sufficient. So it is up to the judges to decide, should they rely on the certified true copies, or should they go ahead to request for the scrutiny of the original forms, because IBC was saying that it will require some time to avail them before the court, even in as much as they are in a warehouse within Nairobi, as they reported. So basically, once that ruling is given, and also the request by 2 voters who want to be joined in the case, then the case proper should begin, the hearing proper should begin, so that the 2 petitions, that is the one by John Jomue and Khalif Khalifa, as well as the other petition by Harun Mao, the former member of parliament for Kilome, will have their stage to make their case. Of course, there was that request to consolidate the cases, so we'll be expecting to hear from the petitioners, because Harun Mao, as a petitioner, has 1 hour to make his case. For Harun Dube, they have about 2 hours to make their case, and then the respondents, for instance, IBC chair has 1.5 hours, and then the IEBC as an institution has another 1.5 hours. For Uhuru Kenyatta, who is the respondent, has 2 hours to present their submissions and also their responses to the accusations that have been leveled by the 2 petitioners. And
Sam, for that. Francis, just paint for us a picture of the political environment under which these cases are taking place. Does it appear significantly different to you from the environment in which we entered a similar petition after August 8th?
There's quite some difference, and in terms of the political environment. Last time in August, when the petition was being prosecuted here at the Supreme Court, there was a lot of excitement, a lot of political excitement. You saw supporters of the then petitioner Raila Odinga here, and the respondent then President Uhuru Kenyatta around here, demonstrating, holding placards and so on and so forth. But the situation is totally different now. Very calm situation, no anxiety within the courtroom and around the precincts of court. Though security remains tight around the courtroom, but when you look at the situation that was then and now, quite different. And even the number of politicians who are making their way to the Supreme Court at the courtroom then in August, compared to how the situation is now, very different. I only spotted Eden Duale, the majority leader in the National Assembly, yesterday. So far, I've spotted no politician coming to the courtroom. And you even remember in August, quite a number of politicians from the National Super Alliance also making their way here at the courtroom. I remember that time the NASA presidential candidate was a petitioner. But now, the situation is totally different. Very little in terms of political activity, but definitely there's a lot of expectation in terms of how the judges are going to deal with the specific constitutional issues that have come up. That is, number one, what constitutes a fresh presidential election, number one. And number two, what are the consequences of a presidential candidate withdrawing from the race? Those are two pertinent questions that the judges will be expected to make a determination on when they hear and determine this matter and make a ruling by Monday this week. So while there is little in terms of political activity, on the other hand, there's a lot of constitutional issues that are coming up that the judges will have to make a ruling on, and definitely provide a way forward guideline, set the precedent for future presidential election as we move on.
Sam, what can you tell us in terms of the presentations we should expect once the preliminary issues are dealt with? What information can you give us in terms of the case that petitioners will be wanting to make this morning?
Well, basically, most of the applications, there were 15 applications that were coming before the hearing can begin, and 5 of them were had in open court. That is yesterday when the rulings were given, and that is specifically to talk about the application by Fred Ngatia, the lawyer representing Uhuru Kenyatta, to have NASA struck out of the proceedings involving that petition by John Muen, where they had been listed as respondents, and that was already ruled upon yesterday and granted as wished by Fred Ngatia representing Uhuru Kenyatta. And so the other application that had been before the court is in as far as the applications to be joined as interested parties, as friends of the court, and that request by Ekuru Court, the presidential candidate for Third Way Alliance, was granted. So he'll be making his presentations. He'll get about 30 minutes to make his submissions on what he thinks would be of importance to the court, as well as to protect his rights. But the other application that was also granted is to have the internal memos from IEBC that was sort of said to have been leaked from the commission. They were also expunged from the court record, so they will not be relied upon in deciding on what evidence is presented before the court. The other application that was also granted from the parties to this case is in as far as the application to have that voter, James Onyancha Minor, who wanted to be joined as an interested party. That was rejected because the court was saying that he's just one of the voters, one of the 19 million voters, and so he should not be allowed based on that, because then other 19 million voters would also have an interest, but they are not being brought to court because there's no sufficient time. So in terms of getting to the presentations, you'd obviously expect the petitioners, because they are the ones who have this case, that is from John Mue as well as Harun Mao, the former member of parliament for Kilome. They'll be making their presentation, so that for Harun Mao, saying that IBC should have conducted the fresh nominations in getting into the fresh election, then he'll make his case and explain why he believes that is the case. And then also for John Mue, because he has leveled a lot of allegations, or rather claims, that support his petition. For instance, also agreeing with Harun Mao that IBC should have conducted fresh nominations, but also the other matters to do with the wrong things in course that he says that were happening at the commission. So he will get an opportunity to explain why does he feel that the environment that IEBC was operating in was not conducive for a free and fair and credible election. So he'll have that opportunity to make all his submissions on that. And then, of course, the President-elect Uhuru Kenyatta, the IEBC who actually conducted this election, will have their time to explain why the circumstances were as explained by the petitioners and why they feel they are not sufficient to warrant a nullification of the presidential election. And
Sam Gituko and Francis Gashuri reporting for us from the Supreme Court. Thank you both. We'll catch up with you shortly. And joining me in studio is Joy Mudiva. She's an advocate of the High Court, and Joseph Simeha, who is a political analyst. And good morning to both of you. Joy, let me begin with you. On the political note, and as you heard from Francis, the temperatures seem to be much cooler. Obviously, we do not have the two main political actors, in court per se, going head to head, as we saw in the previous battle. Yet at the same time, both could be, significantly affected by the outcome of this process. Why do you think there is then that sort of cooling of temperatures, though the stakes really are as high as they were before?
I think one of the issues is, as you pointed out, the fact that the politicals are not directly involved in this case. Because what you saw last time was a lot of crowd surging, and there was need for police to barricade the road to keep away the crowds. You saw a lot of, the pushing and pulling people until to get into the courtroom. It was a lot more crowded. And so the hype at that time was mainly because of the political players that were involved. This time around, you have ordinary citizens who are interrogating the process. And of course, they don't have as much, lack of a better word, as much shine as the politicians would have. And so, I mean, you are even wondering who is Njonjo Moe, who is, maybe only Harun Mwau is a name there that people would readily recognize. So that's one reason. Another reason also is fatigue. This thing has gone on for a really long time. There are people who have simply lost interest, and they've simply checked out of the process. They're like, you know what, when you're done, tell us what has happened. We actually, at this point, we do not mind either way. Just let us know what is going to happen at the end of the day. So there's also the element of fatigue. The other thing also, I think, is people have gotten to a place they've understood the process is not as romantic as before. It's actually, if you sit and listen to the cases and you're not a lawyer per se, you're not really following, you realize this is that part that is very long and very boring.
Right.
And so it might also be one of the things where people are like, you know what, let's start getting excited when it's closer to day 14, when you're getting closer to the end, because at this point there's actually very little to sort of excite the normal Mwananchi. But over and above that, a lot of work has also gone into peace building, bridge building. There's been a lot of talk about let's be brothers and sisters, and I think the message has finally come through where the Kenyans are also saying, look, let's try and carry on as normal as possible. And at the end of the day, whatever happens, we've been there before, we've done that before. It's no big deal. Even if it's another election, then so what? We'll just go ahead and do a new one. So I think the political, Kenyans have come to a place, it's boiled over until it's simmered down.
Right. Joseph, we have the pleasure of looking at the long, boring parts. So in that respect, what are you expecting this morning in terms of presentation? And maybe give us any, tidbits in terms of insider knowledge of the parties who are in case and how they prosecute their style of argument. What can we expect to see?
Well, this morning the court is going to to deliver its decision on, I think there was two applications that were pending. The one on scrutiny, and I forget which other one, just the interlocutor, the preliminary, if you like, procedural applications that are not the main case.
Yes.
They delivered decisions last night on several. This morning, not just two, there were others that were not heard in terms of oral submissions, but the judges considered them based on written submissions. So they are going to deliver those decisions this morning. And then I expect that, just as they said last night during the pre-trial conference, that the case proper will start. You know, the petitioners making their case, and ultimately the respondents making their case. Now we're talking about politicals not being there, but there is one political who is Uhuru Kenyatta. Because Uhuru Kenyatta is enjoined as a respondent. Actually, the third respondent. Yeah, the third respondent, because it's his victory that is being contested. Now it's important, as Joy says, to note that the people who have petitioned are not the political parties that participated in the elections. Previously, the way it came out, it is because Raila Odinga was a candidate and Uhuru Kenyatta was a candidate. Raila was petitioning Uhuru Kenyatta's victory, alleged victory, to nullify it to his benefit. And it's very difficult to run away from that. Yeah. That he could have been doing what he was doing in public interest. So it's very good when you have people like Njonjo Mue and Khelef Khalifa who are petitioning as voters, citizens. And therefore they are doing this as citizens in the greater public interest. They do not want to torpedo Uhuru Kenyatta's alleged victory so that they take that victory. They just want to do this for in the interest of the general citizenry of the Republic of Kenya. So I think it's good because petitions sometimes are just looked at as contests between parties. Whereas actually there is a greater public interest that is actually being prosecuted there, and it gets lost.
Right.
So I presume that when the Njonjo Mue and Khelef Khalifa are presenting, as their lawyers are presenting, and I've looked at some of the documents that they filed, they praise a lot in favor of public interest. Violation of this statute, violation of this constitutional principle, violation of this international law, violation of this, and so on, in the interest of the public. And just saying that, look, we want an election that meets a standard that we deserve as Kenyans. So that I think is important for us. We should look.
Which is very different from when it's painted as, you know, just a political contest, somebody being a spoiler for someone else.
Yes, when, as opposed to it looking like an adversarial thing.
Yes,
like
right.
It's Raila coming there because he's unhappy with Uhuru winning. So he just wants to make sure that Uhuru loses and so on.
Right.
So the public interest in such a petition gets lost. And I think we are privileged as Kenyans that these particular petitions, actually there are two, hopefully we will get to see what public interest is Mwau defending? What public interest are Khelef Khalifa and Njonjo Mue defending?
Is there still the chance for these cases to be collapsed into one? Or does it seem that they will very much, you know, be two separate issues? And how will that affect, you know, the time that the court has to deal with the matter?
It's unlikely that they will be collapsed into one because both of them are taking a different tone to the approach. If you look at the Harun Mwau petition, it was more looking at the process after the order of the fresh election. So he's like, should we have started the fresh nominations? Should we have not? So he's sort of zeroes in on the procedure. If you look at the Njonjo Mue Khalifa petition, it's looking more at the legalese. What basis? What was the ground? So it's difficult to collapse them because they have come with different approaches. And one thing that I think the judges will try to do, they'll also try to help the petitioners to sort of try and zero in on this so that you don't have the situation whereby you're trying to prosecute points that are not your main points. So for example, in the Njonjo Mue case, I am sure we're going to hear a lot about what does Article 2 of the Constitution say about international laws? What does the law really mean with Article 138, with Article 140? What does the law really mean when it looks at the Elections Act? And now expound that in light of the 2013 petition, the decision at the article, the paragraph 290. So it's going to be sort of answering those questions that the running joke, the law is very clear. Right. It will be trying to make that law very clear because we realize that there are so many sections of the law dealing with the issue that we were not sure
very clear about
what the issue was. So that's what the Njonjo Mue petition will do. The Mwau petition, on the other hand, was very particular, saying if the candidates were not nominated afresh, then it meant we had no validly nominated candidates, so we had no election. So his application is much simpler. It's easier to dispose of, I think. So I don't think they'll be collapsed because if they are, one will be swallowed by the other. But I think we will see a lot more time being given to the Mue team than is given to the Mwau team.
Right, but without, you know, prosecuting the case, what arguments do you believe Simeha will need to come out clearly in order for these two camps to make their point?
On the Mwau case, as Joy says, and I think it's the, if you like, he may not agree with me, but the lighter one, because it's about whether the IEBC complied with the High Court order to carry out a fresh election.
And what does fresh election mean?
Exactly. What is the meaning of fresh election? And in Mwau's petition, then he's saying, look, fresh election will require that you have fresh nominations. Did you have the nominations? So that would be, if you remember last night, the Chief Justice asked them whether the parties, they'd agreed on framing of the issues to be, you know, decided upon, examined and decided upon by the court, but they hadn't. And he told them to go and try and together frame the issues. I suppose that will be one of the issues. Can we determine the meaning of when the Supreme Court said go and carry out a fresh election? What is the meaning of that?
Where does it start?
Where did it start? Did IEBC comply?
Does it nominations?
Does it involve nominations, fresh nominations?
Just fresh polling.
Right, or is it fresh polling, right?
Does a can gazettement pass for nomination? Or is it the way we know in law for nomination for purposes of an election? That is the Mwau case. On the Njonjo Mwe Khelef Khalifa case, we have a lot of weighty issues raised. They are raising issues on the environment in which the election took place, whether that was conducive for the IEBC to carry out a free, fair, credible election.
Right.
They are raising issues about disenfranchisement of up to at least 1.7 million voters in 4 counties where IEBC purported to postpone, which the law allows them, but then totally fail. But the law then says that you must carry out then an election to ensure that everybody has a chance to participate, to exercise their right. This is one of the things which is in the documents I've seen they're filed in this petition. They are also raising the environment within IEBC, the disagreements, the acrimony that came out, that impinged on IEBC's independence and ability to carry out a credible election. They will be trying to persuade the court that looking at those things that were happening within IEBC must already persuade you that it was not in a state able to hold a credible election. They are also raising they're also raising that issue that Mwau raised. It's also in their petition, the issue of whether the IEBC complied with the requirement to carry out a fresh election or not. There's a whole host of other issues that they are raising, things done by third parties, like what state agencies did and how it affected the conduct of a free and fair election. In several places they're indicting the police, and in a way they're saying IEBC just stood by. Right. It is the responsibility of IEBC to ensure that it makes demands of other state agencies in terms of their conduct and what they should do to support IEBC to deliver an environment in which we have a credible election. But instead, they seem to be saying, look, IEBC just stood by, and this thing was taken over by the Minister for Cabinet Secretary for Interior, police commanders, and county commissioners. They were the ones making pronouncements and saying this and that and banning rallies and banning protests and so on. And IEBC not doing anything, yet this was to do with an election, where the management, even of security, overall comes back to IEBC, because then the police cannot just do anything they wish to do, where they are required to secure the environment for delivery of an election. So it's a whole host of issues that the Njonjo Mwe Khelef Khalifa petition raises. Right.
I want to talk a little bit about the lawyers, because they are in part the stars of the show, and their style of prosecuting the case could very well make the case or not. So what can you tell us, Joy, about these parties? Let's start with a character like Harun Dubi, who perhaps is a little better known to the public from his days in civil society, and he tends to be a rather colorful personality in the way he speaks, etc. Give us just some knowledge in terms of how you expect these people to present themselves in court, and how that affects, the temperament or the environment of the court, if you like.
And that's what we're even discussing over the break, because I was saying that one of the misfortunes with the Supreme Court is that you don't get an opportunity to bring evidence, to lead evidence by calling experts. So the lawyers must be the witnesses as well as the advocates. Right. And so when you've got somebody who is impassioned, they can do one of two things. Either irritate the judges to a point where they cannot listen to you anymore, and therefore have a communication block on you, or you can engage them in a way that keeps them on the edge of their seats, wanting to hear what it is you're saying. So for example, you pointed out somebody like Harun, who has been more in civil society, and civil society people, we are very passionate about our causes, and we fight to the end for it. And sometimes it serves us in good stead in the court of public opinion, but in a court of law, it becomes an impediment, because you don't get your point across as quickly and as succinctly as you would have. Compare and contrast that with what the style we saw Julie Soweto delivering. It was very meticulous. She was very patient with the judges, giving them time to write. When she was told time is up, she just gave one short sentence and it was over. And judges respond to that, because they say you respect our time, you respect the fact that you're moving at your lordship's pen, and that gives them the opportunity to also interrogate.
Moving at your lordship's pen.
It's true, because they have to record everything down. So if you go there talking blah, blah, blah,
We just
and they
move
cannot
at the speed of tweets.
Exactly.
There you go. All
So
right.
when they find an advocate who takes the time, and that's why you find people like Feroz Norji or even Fred Ngatia will have a lot of leeway with the courts. It's because they have learned to treat the court in a certain manner that lends them to pay more attention to you. But we've also seen, like even in the previous petition, the more youthful advocates getting an opportunity to make a very big impact as compared to the older advocates who seemed to struggle with a bit of the grasp. Like they may not be in this matter, but when you look at advocates like Awele, they brought in such a breath of fresh air, a confidence that we did not expect of young advocates. I mean, I grew up looking up like Akina Limudoga. Those were the guys you wanted to hear in court because they were the older, more seasoned ones. But now you're seeing some of the younger advocates actually stepping up. And not just stepping up, doing the homework to be able to stand, because that's a huge stage. You're looking now in this matter, now they brought in some fresh blood, Akina Wambua Kilonzo, people who we have seen from the days of Goldenberg. He has come a long way until now. He's such a seasoned advocate in the Supreme Court, and now appearing alongside people like Githum Muigai. You have to have your feet firmly planted on the ground. And of course, you can expect Honorable Githu, when he takes the floor, to give us a little bit of very intellectual humor. You have to be of a certain IQ level to appreciate.
And some of us to pause like for 3 minutes, like,
yeah, you get it next.
What are you saying?
Yeah, you'll catch it tomorrow, but eventually you appreciate. And those are the things now that help the judges, because at the end of the day, the judges have to break down what are the bits and pieces and then put together the jigsaw to paint the final picture. So if you've got advocates who are clear on the points, like when Simeka is talking about the Jonjomwe petition, it's a very critical petition in clarifying issues. I hope they don't get sidetracked with the sideshows of what was happening in the streets. Let them stick to bringing up so that we have a decision, unlike the 2013 one that was very lengthy but left us more muddled, like that famous paragraph 290, we will live to rue the day it was ever written. But this time around, I hope they will stick to painting not just the big picture, but giving us the detail that will produce a judgment at the end that will actually move the jurisprudence of election laws in Kenya forward, rather than leave it more muddled.
Joseph, I want you to talk to us a little bit about the public confidence in the court, and although they should operate above politics and outside of it, they are impacted by it and by perception. Do you think the court goes in with that much more public confidence, or rather sits with that much more public confidence than, you know, it did post August 8th, especially now that the public has seen that this is a court that can overturn an election?
Yes, before I answer that, let me just talk about two people that Joy left out. I think you don't leave out Ahmed Nasir. Who in my opinion, you know, has this condescending way of lecturing the court on what they ought to know and what they ought not to know, and what they should have decided and what they should not have decided. I always wonder, like, what are the judges thinking of him when he's doing that? As opposed to people like Awele, as you mentioned, as Julie Soweto, you know, very calm, collected, showing a lot of deference and respect. I think today you will the court. Actually, they after, obviously, Sheikh evidence what is purported to have happened at the Court of Appeal with it not operating, but apparently operating in the night and setting aside orders of the High Court and so on. Those kind of things, let's face it, shake the confidence of at the minimum part of the public. It leaves people wondering, like, are they as independent as we thought? Are they as strong as we thought? Will we get justice? And it's one of the things that NASA has cited by saying that we will not even be party to that, because we're not even very sure that the court will hold its fort in terms of independence and resist the pressure being brought to bear upon it, including through killings. You know, like the shooting of the driver of the deputy, and very unfortunate incident of the driver of the Deputy Chief Justice by some people. So that shakes public confidence a bit. But from yesterday, when they sat there, you know, people follow, again, you know, these things, they fluctuate. People will follow the arguments, what is going on at the court, see the demeanor of the judges, hear the questions they are asking, see the confidence they are demonstrating, and that can easily actually bring up public confidence. Look, hold on, they look like they're okay. They look like they could make an objective decision and stand by it. So I think the hearing is very good. The public hearing, unlike the one where they look at the written submissions and just make decisions in chambers, that public, those public people depending determine take a position and say
whether the court is
credible or not.
Wow. But may I just add something to that? I differ slightly with my brother here when he talks about the erosion of public confidence in the judiciary. In my opinion, they have a role to play in upholding the public perception. Like, one thing I am vehemently opposed to is when they bend the rules to make the politicians happy. Keeping registries open until midnight. That practice has to die. What is this? If people know they have 7 days to file a matter, can they file it within time? The thing of saying we're going to sit extraordinarily, we're going to keep our registry staff there until midnight, people are going to file things out of time. Those are some of the things, in my opinion, that, for me, undermine the credibility of the court. Because if you're willing to bend the rules for one person, why not bend the rules for anybody else? So fine, you kept the registry open after hours to accommodate people, then why wouldn't the Court of Appeal sit at night to accommodate others? Because you sort of open yourself up
on the same matter.
Yes, so there are some things that the court also can do to ensure that they remain above board. Another thing also that we must be alive to is, because they have security of tenure, they also need to be courageous enough to step up to the plate, which is what they did on the 1st of September, I think. They made a decision that shook everybody, but they stood their ground. Now, in such a situation, you need to be aware that there will be pushback. And when that push comes to shove, I think the courts ought to continue to stand their grounds. Because if they get to a place where now they start ceding ground, then you find that it becomes more difficult for them to not just inspire confidence, but to hold public confidence. And with the way things stand right now, the judiciary is the only arm of government that Kenyans can run to. Parliament right now is not, there are some committees that are not constituted, there's some people who are not sitting as well as they should. The county assemblies, there's also a lot of melee going around. You're looking at the executive now is what we're determining who's going to head the executive. So the judiciary right now is Kenya's hope. So they need to be at a situation where they not only stand their ground, as Joseph correctly says, but they also need to be able to push the others back and insist on their independence. Because if they don't, Kenya as a country right now will be lost.
All right. We're taking a short break on Citizen Extra. We're, of course, standing by with our eyes at the Supreme Court, waiting for the judges to walk in so that those proceedings can kick off proper. We're back after these messages.